we are joined on the panel, and we're very, very happy to welcome Professor Carrie Baker, who is a faculty member at Smith College, and who's the chair of the American Studies program, and also a professor of the study of women and gender. And she teaches courses in gender law and public policy and feminist social movements, reproductive justice, among others. She's published numerous books, chapters, articles, and she even shares her expertise with the general public by writing articles for Ms. Magazine and a monthly column for the Daily Hampshire Gazette, which some of you may read. So thanks for joining us. We're also going to have some assistance, I hope, in organizing the panel from Dean Emeritus Howard Kolodner, who was Dean of the Law School, as many of you know, for 17 years, from 1977 to 1994. So Howard, who I hope can hear this, is not easily embarrassed, but I'm going to try. So I'm going to tell you that we recently, the two of us, put on quite an impressive display on the dance floor during our son's wedding reception. So with that, let's start the questioning. Howard, you have some questions for us, I hope.
Unfortunately, our audience has not yet joined in. I hope that as the panel talks, they will do so. But I think I will start out with one question, looking backward at last year when there was a consensus as the panel, as I recall the panel discussion, that the 2019-2020 term belonged to the Chief Justice, who had become the median justice, and his vote was necessary for either a liberal or a conservative majority. But that's obviously no longer true. So what was the defining characteristic of the term?
Bruce, what do you think? Oh, I think you're muted. You've got to unmute yourself.
It's a great question, and you know, I'm struggling to find a theme. I guess I would say two things. One, if there is a center, it's now Justice Kavanaugh, I think. And the second thing that I might say is to follow up on something Leora said towards the end of her remarks. And that is that the Republican appointed members of the court, the so-called conservatives, have to figure out, kind of like the Democrats do in Congress, what the hell it is that they stand for. Because they've got the votes to do whatever they want to do. You know, where's their party discipline, for God's sakes? They don't know yet. And, you know, as somebody who mostly disagrees with all of them, I'm glad they're in some disarray. But I think they probably will come to some kind of consensus. Yeah, Kerry.
Yeah, I'd like to just jump in here. I think they're struggling with their own legitimacy as a court. And I mean, they are obviously out of step with the country as a whole. There are 3 justices put on the court in recent years by Trump, and 2 of them in very questionable circumstances. The Merrick Garland seat, which was held open for 8 months before Gorsuch was appointed, and then the Coney Barrett seat, which was rushed in the last minute right before the election that Trump lost. And I think that the growing emergence of a shadow docket is something that we need to pay attention to, because I think that there are things they want to do that they don't feel like they can do with a full airing. And so they're using the shadow docket to accomplish things kind of under the table. And I want to give two examples. So first, just to say the shadow docket, or if there's students here, are cases decided outside of the regular docket without oral argument, often without a full opinion, and on application for emergency relief. The term was coined in 2015 by William Bowd. And, in this term, a lot of decisions were made on the shadow docket, for instance, relating to things like COVID policies, immigration restrictions, capital punishment, US Census, procedures for election, and obviously abortion. It's a high bar on that posture, irreparable harm, but it appears they're lowering that bar and making decisions that are unpopular through the shadow docket. And two examples would be abortion cases, one that was decided in January of this year and one that was decided more recently in September, which was the January decision was FDA versus ACOG, and involved medication abortion and whether the FDA had to lift restrictions placed on a abortion pill. That was ruled in the lower court that they did, and there was an injunction placed on that restriction. And the Trump administration appealed twice to the Supreme Court. And in the second time it got up there, the Supreme Court overturned the district court opinion without a full opinion, with a 15-page dissent by Sotomayor, and with no showing of irreparable harm. So another example of that is the Texas abortion ban case, SB 8, which went up to the court on September 1st, where, again, the question was whether abortion providers had standing to sue. And the Supreme Court allowed a blatantly unconstitutional law to go into effect and remanded it back down. And that law has now been in effect for 2 months. And, speaking of irreparable harm, and of course, we all know on Monday, they decided in a very unusual posture to have oral arguments, kind of like in Bush versus Gore or the Pentagon Papers. There really have been very few of these emergency petitions where they've actually issued oral arguments and allowed briefs to be filed. They did it all within 10 days. And so it's, I think this is something to keep an eye on, something that's emerging more and more. In a 2019 article in the Harvard Law Review by Stephen Vladeck, a professor at University of Texas Law School, he called attention to the increasing numbers of cases being addressed through the shadow document, both orders and summary decisions, without full briefing and without oral argument. And I fear, considering not only the politicization of the court, but the skewedness of the court vis-a-vis public opinion and sort of, general, and the desire to kind of overturn long-term precedents like Roe v. Wade, that is something we really need to keep an eye on.
Matt, I think your hand is raised.
Yes, I'll lower it now. I just wanted to raise two additional points on the conversation that we're having now. The first is in relation to that shadow docket problem, and it's looking back at the change in the early 2000s with executive signing statements. The Bush administration, George W. Bush administration, stating that it would comply with the Constitution in certain ways, but not being clear on how it's doing that, and as a way for an expansion of certain executive power. So this use of the shadow docket, this use of a need for a quick response without any kind of explanation, is something that is expanding certain types of power through the court, and that goes to the second component of what I would say, which is there's a shift towards saying that the court is not engaging. There's always been a statement that the court isn't really engaging in making political decisions, which is, of course, even if you're saying I'm not doing it for political reasons, I'm doing this because I like the particular skewed result that is going to go towards individuals that I think are going to benefit. So in the cases that I've discussed, the situation, particularly in the Alien Tort Statute case, where Congress has made a decision to support certain industry and to make sure that that industry can expand. The fact that the court says, well, we wouldn't want to be in a position where some other country brought us before their courts to say that we violated someone's human rights years and years ago, and therefore we shouldn't, out of a question of comedy, we should give respect. So that's actually in the Foreign Sovereign Immunities Act case, where Justice Roberts says, for political reasons, we have to respect the fact that our Congress doesn't want to engage other states in discussions over how to interpret genocide. That it's a political decision. It really is. And to suggest that the court is able to step back because that should be left to Congress and that should be left to the executive branch is really to enable slavery, to enable things that we as a country claim to stand against, but doing so from the perspective of being apolitical. So that's something that the court is doing somewhat consistently.
I'll add the fact that the thing that surprised me most in some ways was how little the law changed this term. I mean, with the addition of these, three conservative members of the court, and particularly the last minute addition of Justice Barrett, I expected there to be more dramatic change than it turned out that there was. Often the court continued, even though Roberts wasn't nearly as central as he had been before, they continued to kind of narrowly decide cases, looking at the facts, not necessarily changing the law. I mean, we could say, well, yes, manipulating the facts or distorting them, but nevertheless, without announcing a dramatic change in the law. And I guess I feel like it's likely they've put that off maybe for next term, as opposed to having done it last term when I think I expected it to happen.
Can I ask you all a question about the shadow docket, which I'm so glad Kerry threw it into the mix. What do you make of Justice Barrett's concurrence in the recent decision by the court not to enjoin Maine's vaccination requirement for public health workers? The court refused to grant a temporary restraining order, declining to use the shadow docket, and she wrote about it and basically suggesting that maybe they ought to rethink it. And I wonder if public opinion and whether the court is out of sync with public opinion. Kerry raises that point. Whether Barrett is hearing that. She's been out on the hustings a little bit, and I wonder if there's any portent there. How do you all see that?
She was asked a shadow docket question at the McConnell Law School forum that she was on. I think she's very aware of this, and she got defensive about it.
Yeah.
Alito also made a big speech in which he defended the court's use of the shadow docket, saying, "Oh, it's nothing new under the sun. We've always had an emergency docket." They're obviously feeling a little bit of pressure about these cases, and there have been a lot of them, clearly more than before. I'm not sure that it's possible to view, a decision on any single one. I mean, if you're looking at the phenomenon of the use of this. On the other hand, in individual areas, you can look at those cases. I mean, there were a very large number of cases involving COVID restrictions, which were challenged on free exercise grounds. Religious observers, practitioners objected to being limited in the number of people they could have at church services or even in-home gatherings, Bible reading, Bible study gatherings. And in each and every one of those cases, almost every one of those cases, they won. and the court found some kind of discrimination, therefore making strict scrutiny the appropriate test. Of course, those are, the COVID restrictions are easy targets for finding some kind of exception, because they always divide up activities into categories. And the minute they don't apply universally the same standard, so it gets kind of easy to do what they did in Fulton and a whole bunch of other cases. I think there's an interesting question of how much they changed the law in any of those cases, as opposed to reached results that all of us would not like them to reach. They've tended not to cite to the shadow docket cases in any of their fully docketed cases. So, I'm not sure what to make of it. It does allow them to reach decisions in individual cases that they really, really want to reach. But how much it goes beyond that is not yet clear to me.
Although it can short circuit a decision, it can be the decision.
Yes.
With a time issue, and then the case is gone. And
Yes.
It can be used strategically by parties to get their end result, even if they don't have the law behind them, or the court's not willing to rule in their favor, like in Texas. They
Right.
have won for these 2 months.
Yes. And, obviously there's no better example than a final decision than in all the death penalty cases, which they have handled on the shadow docket when the Trump administration reinstated the federal death penalty. In every single one of those cases, they allowed the person to be executed in the dead of night, usually. So yes, they can use those cases to essentially bring to an end a litigation. Because there's just no way to go back from whatever has been allowed to happen. Yeah, no, there's no question about it.
I think that the discussion, of course, necessarily transitions from look at the last term to look at our current term, where there is no doubt that there will be major decisions, unlike perhaps the narrower decisions of the last term. We may be looking at decisions which make radical changes in the life of the American people. I'm thinking particularly of the arguments in part already heard, but soon to be heard some more on abortion. And also, of course, the argument that we just heard this week on the constitutionality of New York State's restrictions on on carrying guns outside the home. I wondered what we have to look forward to.
So in Jackson Women's Health versus Dobbs, which is the abortion case you referenced, it's a direct attack on Roe versus Wade, an almost 50-year precedent. It involves a Mississippi 15-week abortion ban. And the Mississippi, has argued directly, has requested the court to overturn Roe versus Wade. And we know that 6 of the justices are anti-abortion, don't support Roe. Roberts could potentially not join a supermajority to overturn Roe, but clearly the other 5, appear to be willing to do it. So I think that is something the oral arguments are on December 1st. And that's a case that I'm keeping my eye on in particular.
For a while, a lot of people thought that as a strategic matter, the court would kind of chip away at Roe, continue the move to chip away as opposed to directly overturn it, particularly in an election year, because it would galvanize Democratic voters. But I think after their treatment of the Texas law, a lot of people have changed their mind about the likelihood that the court would do something, more modest than simply go ahead and overturn it. I've heard somebody say that they kind of figure, well, they have the power to do it now, and you never know what the future brings, so we ought to just get it over with. And I guess I wouldn't be very surprised if that did happen, despite all the political reasons why you might suggest caution in an election year.
They don't have a way that I can think of to sustain the Mississippi law without overturning Roe.
Agree.
And it's hard to imagine 5 votes to sustain that law, no matter what the institutional caution might be. So they kind of have to overrule it, which was, I guess, the point.
I don't know, Bruce. I think
Yeah.
you're underestimating
How wily they are.
they are. You know, it's a 15-week ban. It's not a 6-week, a ban, more or less like the Texas law. And, you know, there's some evidence, I think, in the record where the state tried to argue, oh, very few abortions are performed, you know, after that time. That wouldn't fall that wouldn't fall outside the kind of the emergency exception that the law includes. And I mean, I wouldn't put it past them to do that if they really wanted to, given how they've manipulated the record in, you know, so many other cases. But you know, but on the other hand, I wouldn't be surprised if they went ahead and just overturned Roe.
Well, they have to overturn the viability.
Yeah.
You know, which is
Right.
24 weeks, because 15 weeks
Yeah.
is obviously 9 weeks short. And then they'd have to come up with a new theory of why is 15 weeks okay. I can't see them doing that. I don't know how they would do that. I mean, they would have to overturn Casey to uphold the Mississippi law. And if they don't just eliminate it altogether, I can't see them creating a new right to abortion through 15 weeks sort of separately.
Yeah, I'm not saying they would do that, but I actually do think it's possible to use the undue burden test to accomplish pretty much anything you want, since it is all, you know, about the facts. And they have already used that test in ways that seem inconceivable to me. So, you know, under that standard, not under Roe originally, but under the undue burden test. I mean, I wouldn't put, I continue to think I wouldn't put it past them, but I don't expect that to happen actually, in light of, you know, more recent developments in their treatment of the Texas law and the, you know, kind of tone of the arguments. I suspect the federal government's going to be sorry they ever filed the case they filed, since it seemed like the court was definitely interested in shutting them down and denying the federal government power to enforce constitutional rights, even if they would allow the whole woman's health lawsuit to go forward.
I just mentioned there's also a couple of cases on state secrets privilege and FISA. So the FISA case looking at the right of the government to send someone into a mosque to collect information and dealing with questions of profiling. And so I think that the court, again, is usually going to show deference to the government with regard to state secrets privilege. And my guess is that they'd also do so with regard to this type of profiling, although I don't know how this particular executive branch is going to respond to that.
In the gun case, Howard, that you asked about, it was interesting in following the argument. I didn't follow it as closely as Leora did, and maybe Matthew and Kerry too. But it seemed like the argument proceeded on the kind of originalist turf that was staked out in Heller. And one of the lessons I learned from the Heller case is that you can use originalism to accomplish any damn thing you want. You don't need to be a living constitutionalist to do that. And it seems to me it might be a little tougher to use originalism this time. But if the lesson is you can use it for anything, I guess we might see another originalist decision sustaining a right to carry outside the home and outside the context of militias.
Well, you know, the people that were defending the law did a very good job explaining to the court what the history really does show.
Yeah, which
And
is, yeah.
That this kind of regulation is nothing new under the sun and existed, way back in the day.
Yeah.
And many states, had it, had these kinds of restrictions, but the court wasn't interested in hearing that.
Yeah.
And so pretty much like Scalia did in Heller, any part of history that doesn't support the view he's already taken for other reasons, he just kind of turns a blind eye to it. And it seemed like the court wanted to do that here as well. Just selectively consult history.
Yeah, I've always thought it was a good thing to, if you were going to be a lawyer, to be a history major first, but maybe I'm wrong.
Yeah, I mean, I have to say the thing that upset me the most, I don't think I've ever been quite as upset by any Supreme Court oral argument as the gun case, I have to say. And probably that's because I realize that it will directly affect me every single time I walk out of my apartment. Every single time. Every person in the state, in the city of New York will be affected. Their entire life will change. And the court seemed completely uninterested in that. All they could talk about was the self-defense rights of the person who wants to carry a gun, as though there's any evidence that people have effectively defended themselves, in that kind of situation by having a gun and being surprised by, an attack or a robber or something. And they had no interest in the impact that this would have on ordinary citizens and the way that they live their lives. I mean, it was extraordinary to me that they could be so disdainful. Maybe they just don't live regular lives. They're chauffeured around in cars, and they work in a building where there's a metal detector and no guns will be allowed. And so, somehow or other, it just isn't part of their world experience. But I was just shocked at the fact that they paid so little attention to the impact on ordinary citizens.
Well, I mean, does that go back to the history of at least in recent years, distancing the court from any kind of social fact, denying that sociology kind of makes its way into the determinations Congress made when it passed laws? And if that's not the case, then we're going to read the laws for what they say and with our particular view of what they were intended to say at the time. I think that that's the issue with originalism. That's the issue with any kind of purported strict reading of a law, is that it is meant to exclude the concerns that that might exist based on social facts of how of what the law actually does and the intent of protecting populations. I don't think that anyone is really calling, well, some people are calling for watering the tree of liberty with the blood of tyrants, but that's something that I thought we had kind of moved beyond allowing to the general population on a day-to-day basis with whomever they consider to be tyrants around them. So I think that shift is something I would imagine that this court, if it cared about reality, might want to view a little bit differently.
So I don't know, we've gone over obviously, but I don't know if there's any member of the audience who's still stuck with us who has a question they'd like to ask. You can, I guess, go ahead and raise your hand and we'll try and find you. I don't, because I mean, my suspicion
if you raise your
is,
hand, you'll pop to the front.
yes, that's exactly right. But not seeing that, and maybe the time has come for, I don't know if anybody has any concluding remarks that they'd like to add to the panel's discussion, or not, or anything you were dying to say about the court this term that you didn't get a chance to, or next term. I'll say one thing. One of the things that surprised me was actually Justice Barrett's questioning during the oral arguments. She asked really good questions, very clearly posed, not sort of with an ideological slant. Now, often justices in their first term are, kind of laying back and not showing, their true colors during that first term, particularly if their ascendancy to the bench was a little controversial. So, it's hard to know whether that will continue. But even the positions that she's advocated in some of her separate opinions have been, more moderate, more kind of, I'll say, commonsensical in a way than I was really anticipating. So that's one thing that did surprise me, which I feel like I wanted to mention just on her behalf, because I may not feel so kindly towards her next term after this term.
I'm going to say something I may regret too, and that is that I guess I'm beginning to think that this use of the shadow docket has been maybe a net positive rather than a net negative. And that's because it has illuminated how partisan this court is. It was used less than 10 times in the first 15 years of this century, and then something like 40 times during the Trump administration. And then, of course, there's been a few instances during the Biden administration. And the outcomes achieved during the Trump administration are so different in terms of deference to the executive than the Biden administration. The fate of the rule requiring asylum applicants to stay in Mexico is a good example. Absolute deference to the executive on the shadow docket when Trump makes them do it. No deference at all when Biden lifts the rule. I think people see that. And I think that the more people see how the court is, what it does, how it operates, the better that is for the prospects of American citizenship. I'm not worried in the long run about the rule of law. Perhaps I should be, because I think the public is capable of being a guardian of the rule of law if it understands what's going on. So I think there's been great public education. And I think that's the thing that Alito is the most scared of.
Well, the court's popularity rating has fallen significantly. I see some hands up. Eileen, did you have a question? You can unmute yourself and just ask it.
I'm just looking for opinions on the idea of increasing the size of the court.
I think it's very, very, very unlikely that it will happen. First, because Democrats are having a really, really hard time getting anything done and may completely lose that ability after the midterms, but also because all that's going to happen, if that happens, if time Republicans are in control, they'll just add more justices. And before you know it, you have a kind of an unworkably sized court that really can hardly even function. But I don't see any real chance that that's going to happen. I don't know if anybody disagrees.
Well,
I don't think it's likely to happen. Oh, Matt, go ahead.
No, I was just going to say that I think that the advice being received by the Biden administration is in part due to people who have been making the argument for that expansion, for professionalization in some way of the court, for term limits. I think that there's a lot of discussion that is going to be there, but they haven't come out yet with a determination of something that will work. And so I don't see any movement anytime soon.
Yes, and appointing that commission, we know that you want to kill a good idea, appoint a commission to study it, and so when he did that, I figured that we weren't going anywhere with this.
You know what? I think we are, we're law professors, and so we tend to be court-centric, and we tend to be reluctant to embrace big institutional changes on the court. And I know that I really wouldn't like to see the court become a 15-member court. But I wonder about my own reluctance to think that that's a good idea in light of the potential harm that they can do. One of the things that really surprised me about the commission, in light of this, what I just said, how conservative we law professors tend to be with respect to settled ways of doing things, is that there was a lot of suggestion that Marbury against Madison itself ought to be disregarded or somehow overruled, that the very idea of constitutional judicial review now ought to be challenged. And
Well,
as
if
a
you don't
child
like
of
the
the Warren
court-
court, that's a tough bridge for me to get across.
Well, if your ambition is to try and keep cases away from a court that you don't like very much,
yeah,
that
Yeah.
is obviously one way it could be done, but of course it has bad consequences
Yeah.
if the court changes, and I mean, you could imagine it having exactly the opposite effect in
Yeah.
keeping cases away from the court in other circumstances. But it's not so much not being willing to rethink. I just think as a matter of politics, there's just no
Yeah.
chance.
Oh, no, I agree with you completely, Laura.
I see that Ralph has his hand up.
Yes. Thank you, Leora. Actually, my question was along the same lines as Eileen's and the subsequent discussion on reforms to the court. And I agree, if you don't want something to happen, you appoint a commission to talk about it. But my question was, are there reforms that folks think might be a good idea? Aside from the expansion of the court, which is extremely unlikely, and term limits, which I don't think is going to happen either. Are there other things, for example, reforms that might affect this shadow docket, as we now call it, reforms that might affect the kinds of cases that the court hears, because Congress does have the ability to change the court's appellate jurisdiction. What kinds of reforms would folks like to see?
That's a damn good question, because here I sit as dissatisfied as anybody, and you ask me in terms of big changes, how should it be different? I have trouble thinking of any where I don't think the cure is going to be worse than the disease. The Congress not only has possibly plenary control over the appellate jurisdiction of the Supreme Court, although I wonder a little bit about that after Boumediene, it also has very, very substantial control over what remedies the court can give in particular cases, even including constitutional cases. And that could be something Congress could do. I am so hesitant to start calling for stuff like that, because I'm scared of Congress too. But Ralph, I really do understand what lies behind your hope that there's got to be something. I can't come up with anything that I feel like I could embrace.
Yeah, I think it's tough. I mean, the only, and you've kind of already explained that this isn't going to happen, which is true. The only thing that's been suggested that I really wish had been the original design is the notion of, term limits for the justices, so that every president who, within a 4-year term would be able to pick two people for the court, that you couldn't have this kind of random arrangement where, some Democratic president is lucky if they get one judge and Trump gets 3 in 4 years. But I do think that making that effective immediately certainly would require a constitutional amendment, which
will
is
never
not
happen.
going to happen.
Right.
So I don't expect to see that reform, but I do think that in light of how we've seen the randomness issue play out in terms of the composition of the court, it would be better if we could avoid that, because I think it brings in its wake a lot of other unfortunate facts about people strategizing about when to or whether to retire from the court, and various other problems that an effort to maybe put off taking certain cases until the court is has a different membership, or whatever it is. I think if there were regularity, we'd be better off, but that's not going to happen.
I want to add one thing, which is just another thing that has been recommended. Another proposal has been some kind of professionalization, making sure that people are brought from a group of judges who are trained and who are kind of moderate by design. I think one of the problems with that is a lot of us who got interested in law saw changes, societal changes that came through things like the Warren Court, and that may have been a moment in time, but the concern is that sometimes if you just try to bring in the most moderate voices on every issue, what you're doing is you're freezing that moment in time as you move forward. And to the extent that our court, that we live in a time that has a lot of inequities, if you just bring in people who are moderate, and whatever that means for us as a polity, then it would be a prevention of law seeing things differently. And there are some benefits to that, even though it might mean swinging back and forth in ways that are somewhat horrific as well.
Yeah, I mean, unfortunately, we're going to have this court for quite a long time. And so, that's something to really grapple with, that there doesn't seem to be, unless, lightning strikes, it doesn't seem like we're going to see a turnover, anytime in the foreseeable future. Okay, so why don't we call it a day, and bring this to a close. If I had a gavel, I'd hit the gavel. I really appreciate everyone's participation and the patience of the audience. And I'd say same time next year, but I don't know if that's the case or not. And so I think I will take the liberties of the convener and end the meeting, unless there's something I should take care of before then. No. Okay, that's what I'm going to do.
Thanks, everybody.
Bye.
All right, thanks, everybody. Good to
Bye.
see everybody.